Good morning, everybody. This morning, we will deal with applications for leave to cross-examine that have been brought by various implicated persons. But before we start with that, I just want to deal with one issue and make some remarks in regard to something else. The one issue is the issue of Mr. Zinhle Manyi. I have been furnished with an affidavit by him in which he explains the text message that he sent to Miss Williams on the day that Miss Williams, or second day that Miss Williams was giving evidence, or was it the first day? And it would appear to me that it is arguable that he may not have intended anything wrong, but that may have to be dealt with in due course. So I think from the Commission's legal team, I want to ask Mr. Malega whether you have any suggestions of how we should, when we should deal with that, or whether you might wish to have more time as the legal team to reflect and then let me know in due course.
Yes, Judge, I would not want to express my own individual view without conferring with my fellow colleagues, especially our leader, Mr. Pretorius.
Yes.
But I can indicate to you that the provisional view we expressed in the corridors is that since Mr. Manyi has undertaken to appear before you, that issue should be dealt with together with the entirety of his evidence, as and when he presents it before you. If things do change, I will let you know.
Okay, shall we then say the legal team will reflect further on the issue, and when we resume next time, they can just indicate whether that provisional view stands or whether there is another suggestion.
Thank you, Judge. We will then confirm our position finally on record later on.
Thank you. And then the other issue or remarks that I just want to make relate to two things. One is that earlier this week, there were some news reports that suggested that as chairperson, I had said that implicated persons who have applied for leave to cross-examine witnesses will have to undertake to give evidence in the commission if they want to be granted leave. I caused a correction to be sent out to media houses, I think 2 days ago, to say that I had never said that, and to indicate what had happened, which may have led some people to think that the commission had said that, namely that a member of the legal team had previously indicated that that would be the stance of the legal team in regard to the applications, but that I had not myself said that. But I haven't seen in the media or heard anything to suggest that the media statement that was issued to make that correction was published. So I thought I must just make that clear, that I have not said that, and I've not made any decision on that. It is a matter that will still be argued, and I would hear all sides, and at the right time make a decision. The other remarks I want to make relate to the call that I have been making to people in our country who have or may have knowledge of the allegations that we are investigating to come forward. And in particular, I have addressed the issue of past and present members of the executive who may know something, as well as past and present directors general, deputy directors generals, chief directors, and any employees, officials of government to come forward. In the Sunday Times this past Sunday, I did see an article indicating that a former minister of communications, Mr. Mcebisi Jonas, and some past officials in the intelligence and or secret service, Mr. Njenje and Mr. Sheikh, according to the article, know something, and they said they, according to the article, they would be prepared to give evidence in the commission if called upon to do so. I just want to take this opportunity to commend them for their decision to come forward and make themselves available. I have asked the legal team and the investigation team to please waste no time in contacting them so that they can be interviewed to see whether they have any knowledge of matters that we are investigating that they can come and testify about. We hope that more and more people in the executive and others who may know something about what we are investigating will make a decision that they will help the country to know exactly what happened, and that they will not keep quiet with important and material information. Thank you. Those are the remarks I wanted to make. At this stage, therefore, in terms of the arrangement that we have agreed upon with Counsel on all sides, we are going to start with the applications for leave to cross-examine that I have indicated seem to require serious debate, and Mr. Helens will be the first one to come forward and move his client's application. Mr. Helens.
Thank you, Chair. Mr. Chairman, I represent Mr. Ajay Gupta in his application to cross-examine Ms. Mentor and Mr. Maseko. Just to sketch by way of background for the benefit of all concerned, I'll commence with the procedural framework against which this application is brought, so that we are all foursquarely in focus as to what it is that you have to exercise your discretion about. And I commence in my written heads of argument, my written submissions rather, in paragraph 1, the rules governing proceedings of this Commission of Inquiry provide in Rule 3.3 thereof that if the Commission's legal team intends to present to the Commission a witness whose evidence implicates or may implicate another person, it must, through the Secretary of the Commission, notify that person, implicated person, in writing within a reasonable time before the witness gives evidence that he or she or may be implicated, is or may be implicated by the witness's evidence in what he or she is, in what way he or she is or may be implicated, and furnish him or her with the witness's statement or relevant portions of the statement. And then further, of the date when and the venue where the witness will give evidence, that he or she may attend the hearing at which the witness gives evidence, that he or she may be assisted by a legal representative when the witness gives evidence. Then we make the submission that of central significance to the issue to be argued before this Commission is the provision contained in Rule 3.3.6, which provides that if he or she, a witness, wishes to give evidence himself or herself, to call any witness to give evidence on his or her behalf, or to cross-examine the witness, and the word is or in between those, he or she must, within 2 weeks from the date of notice, apply in writing to the Commission for leave to do so, and that the chairperson will decide the application. Now, it is precisely against that framework that I now move you to exercise the discretion, and it's a discretion undoubtedly that you have. And nothing I say detracts from the fact that we would be asking you to exercise your discretion in our favor. Now, in terms of the provisions of Rule 3.4, an application...
I'm sorry, Mr. Helens, I'm sorry to interrupt you. I just need to get my registrar to get me something.
Thanks, sir.
I'm sorry, Mr. Helens, for that. Yes, you may proceed now.
Yes. My learned friend, Mr. Malema, just pointed out to me that Maleka. I'm not unfamiliar with the name Malema. Where I said witness in paragraph 2 of my heads, I meant implicated party. So if an implicated party wishes to give evidence himself. Now, I was pausing to say, a la 3.37 of the rules, that there is undoubtedly, because of the nature of these proceedings not being a court of law, either civil or criminal, that the discretion, that the decision to allow cross-examination and to allow the leading of evidence is your discretion, unfettered, as I will submit later, save for such imperatives that come with your having to apply a fair process under our administrative law. But turning back to the heads, in terms of the provisions of Rule 3.4, an application in terms of the above rule must be submitted in writing to the Commission, and it must be accompanied by a statement of the implicated person responding to the witness's statement insofar as it implicates him or her. The statement must make it clear what parts of the witness's statement are disputed or denied, and the grounds upon which those parts are disputed or denied. Then, Mr. Chair, those essentially are the rules now to be applied in considering in this instance whether Mr. Ajay Gupta should be given permission to cross-examine Ms. Mentor and Ms. Maseko, obviously through counsel. Now, if I might just flick from the heads to your bundle D3, you perhaps don't have to go there, yes. But I'm indicating that an application in terms of Rule 3.4, accompanied by an affidavit, both in regard to Ms. Mentor and Mr. Maseko, have been filed by Mr. Ajay Gupta, and that notice reads as follows. Take notice that the applicant hereby makes application to the Commissioner for leave to cross-examine the witness, Mr. Mcebisi James Maseko, and the same notice is given, I won't read that, for Ms. Mentor, in relation to the whole of the contents of his affidavit, the respects in which the witness's statement is disputed, denied, and the grounds for the disputes and denials are self-evident from the annexed statement of Mr. Ajay Gupta, and there is such a statement filed with the Commission, both in respect of Mr. Maseko and Ms. Mentor. In considering this request to cross-examine the witness, the Commission is asked to consider the following. The function of the Commission is to establish the truth in relation to the areas of inquiry referred to in the terms of reference. Although the Commission's work is that of an inquiry and the process of the Commission is not the same as a civil or criminal trial, it is nevertheless so that cross-examination has historically been shown to be the best mechanism for testing the reliability and veracity of evidence tendered by a witness. Without cross-examination, and more particularly adequate and effective cross-examination of contentious evidence, the Commission would be deprived of this essential tool for the testing of the reliability and veracity of the evidence. The statement of Mr. Ajay Gupta raises clear disputes of fact underpinned by his own evidence and demonstrating the need to test the reliability of the witness that has given the evidence before the Commission. In addition to the request to cross-examine the witness, it is strongly argued that the witness should not be consulted with on the contents of the sworn statement by Mr. Gupta by the evidence leaders, and that cross-examination should take place without the witness being precognized, as I corrected it the other day, precognized, as this has the potential to enable the witness to adjust the witness's evidence in anticipation of cross-examination, thus substantially weakening the power and effectiveness of the cross-examination. Now, those are the grounds for the application. I'll turn now to my heads, where we argue why that should be so. I do undertake to be as brief as possible to save the time, but as full as is necessary.
Yes.
Now, under the heading, the principle behind a right to cross-examine, we state that the terms of reference of the Commission shall not be repeated herein, as they are well known to the Commission. Suffice it to say that the Commission is enjoined to investigate the matters of public and national interest concerning allegations of state capture, corruption, and fraud. In so doing, the Commission is enjoined to inquire into, make findings, report on, and make recommendations concerning a list of issues which could be extended in the future, but which issues are set out in paragraphs 1.1 to 1.9 of the terms of reference. Extensive reference will be made, if necessary, Mr. Chair, because we have given you all the references in footnotes, and perhaps reading some aspects of the law where they've been quoted to you might not be fully necessary, but we say extensive reference will be made to the law in relation to commissions of inquiry, and in particular as set out under commissions by D.W. Friedman in LAWSA, and we give you the reference. Now, before turning to that law, that which we submit the Commission must foursquarely face is that it has been appointed not only to investigate the matter, but inquire into, make findings, report on, and make recommendations concerning the various paragraphs of the terms of reference. And we submit that it is axiomatic that the Commission is required and must and does see its duty as being to conduct an objective inquiry leading to objectively justifiable findings, reports, and recommendations. It is not the function of the Commission, nor does the Commission purport to see it as its function, to receive into evidence and into the body of information in the widest sense that it is prepared to take into account evidence or information which is either not objectively reliable or not credible or untested by some method or another. In other words, we submit, in order to fulfill its mandate, the Commission has to make findings, report and make recommendations which are justifiable and objectively sustainable in their import and in their conclusion. We recognize that a Commission of Inquiry is not a court of law, neither of a civil or criminal nature, and that the Commission is entitled to take into account a variety of sources of information. However, when the evidence of a witness is placed under oath before the Commission, and that evidence is capable of being tested, both for reliability, accuracy, and indeed veracity, this Commission should find it inconsistent with any principle of natural justice that a party affected or implicated, in quotes, by the evidence should not be entitled to cross-examine. The Commission should find it, and we make this submission firmly, the Commission should find it nearly impossible to conclude that a valid finding, report, or recommendation could ever be made by it, based in part or in whole on evidence which has not been tested or has been untested. Cross-examination has, throughout the history of the law, been demonstrated to be the most reliable mechanism available to human beings for the testing of the veracity, reliability, and accuracy of the evidence of any witness. We submit that the starting point of the decision whether to allow cross-examination of any witness, but in this instance of the witnesses Ms. Mentor and Mr. Mcebisi, should be that the natural inclination that is in accordance with the principles of natural justice, which this Commission is enjoined to apply, is that cross-examination should be allowed. The Commission should reluctantly consider a reason why cross-examination should not be allowed. In other words, we would submit that as you exercise your discretion, the principles of natural justice should compel you to say, sir, I should allow cross-examination. Why should I not? And the why should I not reasons must be compelling indeed before you allow yourself to take into account evidence that has not been tested by, dare I say it, humbly, able cross-examiners skilled at getting to the bottom of a story and rooting out the truth. You would deprive yourself of that tool. Now, the facts in the instant case is the next heading. The Commission has heard the evidence of Ms. Mentor and Mr. Mcebisi. It has been provided with a detailed statement in respect of the evidence of each of the witnesses. The material difference between the evidence of Ms. Mentor and the evidence of Mr. Gupta, as well as the differences between the evidence of Mr. Mcebisi and Mr. Gupta, are quite clearly evident from a comparison of the contents of the two statements, as these written submissions are to be, the detailed differences will not be addressed in these written submissions, as these written submissions are to be made in an open session of the Commission, and for the reasons more fully set out later in this argument, it's suggested that neither witness nor any witness in general should be precognized as to the nature and extent or content of cross-examination before that cross-examination takes place, and therefore not precognized as to the evidence adverse to the witness's version prior to cross-examination. Now, what I mean by that, you, sir, Mr. Chair, understands, but let me just adumbrate on that very briefly. The witness has given evidence. The witness presumably does not know what version Mr. Gupta has as to the events or non-events contained in that evidence, and in the ordinary course would be cross-examined, and if there are flaws or difficulties in the witness's evidence, those would be rooted out in cross-examination. In the normal course, and in a civil trial, of course, or a criminal trial, there would be opportunity for re-examination, where those areas where the witness may be said to have had difficulty or may indeed have had difficulty are canvassed with the person who has produced that evidence. Now, we know this is a commission of inquiry and it's not a civil trial or a criminal trial. But nevertheless, if you allow precognition prior to cross-examination, there is the danger of the effectiveness of cross-examination being blunted by an opportunity to rethink and adjust. But I'll deal with that more fully. But just to explain what we mean by precognition. We make the submission, sir, that in ordinary civil and criminal litigation, the power of the unexpected question or even the power of surprise in the questioning is well known and accepted. The reaction of a witness to either a version put to him or her or a question which is fundamentally difficult for him or her to answer is an essential feature for the trier of fact that has to be observed in the moment that it takes place. The milk of human kindness, if I could use that phrase, may want to extend to protecting a witness from that which might appear to be harsh cross-examination or unexpected questioning, where the witness is, so to speak, put on the spot. But it is the very essence of the power of cross-examination that that examination be made with its power and effectiveness not having been watered down by the witness being precognized as to the likely questioning to be expected. On a theoretical basis, for example, if the evidence leaders or the legal advisors of particular witnesses are entitled to apprise the witnesses of the contents of Mr. Gupta's evidence in this instance, and to consult with them on these issues, and to precognize them of the points of difference, the witnesses may well be tempted to adapt their evidence, his or her evidence, in advance of cross-examination. Now, I make this submission with absolutely no aspersion being cast on the bona fides of evidence leaders or the legal representatives of witnesses. They are all honorable men and professional men and women. It is simply a fact that the temptation exists with advance notice of likely topics of questioning for a witness to adapt the evidence on the part of the witness to accommodate the otherwise unexplainable. And that is a danger, we say, should be avoided. It is therefore submitted that precognition by anyone of the contents of the answer given in evidence of Mr. Gupta to the two witnesses should not be allowed. It is also submitted that the evidence should be capable of being cross-examined without time limit or artificial constraint, such as constraint as to topic or length or breadth of cross-examination. Experience shows that cross-examination is only effective if the cross-examiner is able to build that cross-examination concept by concept, question by question, to reach a point where the veracity or the reliability of a witness is adequately tested. It cannot be reduced to so low a threshold as the mere putting of a version of, in this instance, Mr. Gupta, to the witness and awaiting the answer thereto. The cross-examination must comprise the full gamut of the tools of cross-examination available to the cross-examiner, question by question, as a point is built up to and brought to a head. Now, what I'm about to, in the next paragraph or so, explain is perhaps the art of cross-examination or the real power of cross-examination, and we say it is necessary in the instant case. So we say, for example, it is often so that in cross-examination, disparate questions on disparate issues can be asked, which have no apparent interconnection, until the jigsaw puzzle of the evidence is drawn together by further questioning being put to the witness, which draw the picture in culmination of the cross-examination neatly together.
Well, Mr. Helens, is your submission that the Commission's legal team, once they have, as they now do, an affidavit from your clients setting out their version, are not entitled, before you cross-examine, let us say, Mr. Jonas? I have to try and remember.
No, I don't appear in the Jonas case.
Oh, okay.
Make the example Mr. Maseko or Mr. Mentor.
Yes, yeah, Mr. Maseko or Ms. Mentor. Are you submitting that the legal team of the Commission should not, before you get the opportunity to cross-examine, call Mr. Masego or Ms. Williams and say, this is what you told us in your statement, and we have now got Mr. Ajay Gupta's version. What do you say about this and that he says? Because he denies what you said about him, and this is how he substantiates his denial, and hear what she has to say.
Let me answer that in a twofold manner. I'm not sure whether the question you asked, Mr. Commissioner, is one or the other. What you ask is, are the evidence leaders not entitled to put, let's make Mr. Maseko the example and stick with him, yes, without picking on him.
Yes.
Mr. Maseko cannot be asked by the evidence leaders questions in continuance, so to speak, of the evidence placed before the Commission, or are you putting to me that they should not be able to consult with him beforehand about all of the issues and then in full Commission deal in the way that you suggest with his evidence in the light of consultation?
Oh yes, it's both. It's both.
Both?
Yes, yes.
Well, we would be foursquarely against that for the reason signaled earlier. And what I have to say here, I won't say it again.
Yes.
The professionals in the legal team are entirely honourable people. But it's if the witness is not caught unawares, if the witness is not put under cross-examination in the normal way, then the witness has time to debate the implications of the differences, to reconsider her evidence, maybe to the astonishment of the evidence leaders change her version, but she has the full luxury of adjusting her evidence, if it so happens, to deal with the contrary version. Now, why would you be served better by such a process than by a process which operates as follows? Her evidence has been completed in the sense that all of the evidence that the evidence leaders wanted to place before you has been placed. The duty of cross-examination is twofold, as you are aware. It is to, by means of questioning, test the accuracy and the adequacy and the reliability of the evidence, and also to put a version. Cross-examination is nothing without a version. We would have to put the version of Mr. Gupta to the witness during or as part of the cross-examination, but coming only once the witness has been thoroughly tested, and in the context of being thoroughly tested on her evidence. What would then follow would be the full right of the evidence leaders, not on behalf of a witness who is their client, because we know the witness is not their client, but on behalf of the Commission, to deal with the issues raised in cross-examination, the version of Mr. Gupta, in precisely the same way as they would have done before cross-examination. But the difficulty would be that the effectiveness of cross-examination by the method that you pose, with both precognition and pre-leading before cross-examination, would blunt the very sharpness of the tool of cross-examination.
Well, Mr. Helens, of course you are aware, as all lawyers here are, that in our legal system we have motion court proceedings in our courts, and where, in terms of which a person who wants to bring proceedings has to do so by way of affidavit, and the respondents must file affidavits, and the applicant must file a replying affidavit. In that case, all parties put before the court their full versions. And you are aware, as all lawyers here are aware, that there may be disputes of fact that arise in motion proceedings. and then that in such a case, the court may refer certain issues of dispute to oral evidence. When oral evidence happens, cross-examination happens. As far as I know, everybody accepts that that's fine. So in that case, if you appear for the respondent, you will be cross-examining an applicant who has come to court to give evidence knowing fully what your client's version is. And we accept that as fine. So why should it, in principle, be problematic if it's a commission of inquiry, if a witness is to know the full version of the persons that he or she implicates before he or she is cross-examined?
The answer in a nutshell is this, Mr. Chairman, and I won't spend any time on it at all, but on this initial aspect, we're all aware, and the public should be aware, that motion proceedings are designed to be brought where there are no material disputes of fact, and then ultimately the decision is really the law applied to the facts which are not materially in dispute, which is why the mechanism of opposed motion proceedings, precisely in the way that you suggest, is designed for the speedy resolution of disputes. It is so that where disputes of fact are foreseeable, etc., an application will be simply dismissed. And the reason for that is that the primary way of resolving disputes of fact is more by trial with cross-examination, in the context of the inquiry, by evidence with cross-examination and possible re-examination with not such heavy labels to them, but generally that format. The reason why an application will be dismissed because of foreseeable disputes of fact is because the preferred method of testing evidence, namely by trial, was attempted to, by design or by error, to be avoided. And the lesser mechanism, I stress, and this is the heart of my answer, the lesser mechanism, the less preferred mechanism of resolving the disputes of fact is by referring motion proceedings to trial or to evidence. Why is it lesser preferred? Because the real method is the described method in a trial. So what you, in your exercise of your discretion, have to determine is, would you choose the lesser mechanism, the less desirable mechanism? Because let me say this, in an opposed motion referred to trial or referred to evidence, the dangers of which I speak would be present. And therefore, it is the less preferred method of getting the number of a dispute to be determined by the trier of fact in a satisfactory manner. And I ask of you, what advantage would there be to you to choose, I ask it rhetorically of course, to choose the less preferred method rather than the age-old preferred method?
Well, what you have said in response to my question suggests to me, understood in the context of the question, that even in an adversarial process, such as litigation is, there are situations where cross-examination is permitted to take place after the witness has had sight of the full version of the other side. That's what emerges from that.
Yes.
And the question then that I put to you is, if that is acceptable in an adversarial scenario, why should it be unacceptable in an inquisitorial scenario such as the one we have in the Commission?
The answer is twofold. Firstly, it is acceptable as a second-class option in the discretion of the judge who has found himself in a position where something that should have been brought by way of trial has been brought by way of motion. And our law is full of cases which tell the judge that he should dismiss the application, refuse to send it to trial or to evidence because the less desirable method has been chosen. But it is so that in relatively rare circumstances that does happen, as you correctly point out. But it is the exception rather than the rule. Why is it the exception rather than the rule? Because the best mechanism for testing the veracity and reliability of a witness is the trial situation. That's the first part of the answer to your question. The second part of the answer is this. You are the pursuer of truth incarnate. You should choose the most effective mechanism by which you get to the truth. Now, the precognition consequence of the opposed motion referred to evidence example that you give is a second-class method. It blunts cross-examination. It has the potential for the imagination of the witness to embellish, to disembellish, to change stance, to change emphasis, and to serve you less well. Now, I assure you, for the most part, I hope for the whole part, there would be competent cross-examiners before you who would not dilly-dally and ask questions like baby counsel might do just for the sake of being a rabbit in headlights and not knowing what to ask. There will be trenchant cross-examination to the issue in question. And as you sit back in your judicial chair and consider the evidence, either post-precognition a la opposed motion referred to trial, or as you sit back in your judicial chair after watching the live cross-examination with no precognition, notionally the surprise of the witness at being caught in a lie, to put it very prosaically, or the ready and quick answer to that which looked like on paper a massive problem, with the honest witness saying, oh, but you misunderstand, it's this. And you know in your judicial soul, this person didn't even know the question could be coming. I believe him, I believe her. Or, whoa, look at that. The blush, the turn, the hesitation, the gulp of water, all those demeanor things. The effectiveness of you observing those things firsthand with a precognition scenario versus the live, what I'm calling the live scenario, you would deprive yourself of that very benefit, and you would wonder in the rearview mirror of your decision whether you might not have best been aided without precognition. That is my answer.
It may well be that you are right, but obviously other factors also need to be taken into account. Certainly where one deals with a witness who is honest but may be mistaken in regard to certain things. If that witness, prior to cross-examination, is confronted or is shown the version of the implicated person that he or she has implicated in his or her statement or evidence, there is a possibility that that witness might say to, for example, a member of the Commission's legal team, you know what, I think I was terribly mistaken in regard to this and that and that. Now that I see what Mr. Ajay Gupta is saying, I think I was mistaken. Now, let's assume that we are dealing here with a witness who had implicated a particular implicated person in about 40% of his or her evidence. But once the version of the implicated person is shown to him or her and is an honest witness and is able to say, for example, no, actually 20% of this 40% is based on a bona fide mistake on my part. Now, if that were to happen, when that witness is then called, for example, either you having been told by a member of the Commission's legal team, or a member of the legal team putting questions to that witness before you cross-examine, might well say, actually, there is a concession that this and that and that and that, the witness was mistaken. The only issues on which she or he insists are A, B, C. So in that way, cross-examination, the time to be taken by cross-examination is curtailed seriously, and the time of the commission is saved. The saving of time, the saving of costs are all very important matters as well. So it may be that in the case of a dishonest witness, maybe that won't happen, but in the case of an honest witness, would you not concede that that is possible, it can happen, and therefore that consultation by the Commission's legal team with the witness to look at the version of the implicated person could help. And in this case, maybe I should just say this. My understanding of the position of the Commission's legal team, and they say so themselves, and I think correctly so, is that they are not here to prove any allegations of state capture or corruption and fraud. They do not represent, the witnesses they bring here are not their clients. They are here to help the Commission to get all the relevant evidence, whether the evidence tends to show that there was no state capture, there was no corruption, there was no fraud, or whether it tends to show that there was corruption, there was state capture. They want to put that before the Commission. To the end, I think the rules say they will ask questions on witnesses, including witnesses who are not implicated, witnesses who come here to give evidence that implicates implicated persons. They will ask them questions aimed at establishing what the truth is. And so in other words, they will ask them tough questions where necessary. So against that background, and with the example that I've put to you, what would you say?
Well, I would say the following. In your other life, you are a judge of the Constitutional Court, and in your entire judicial exposure up to that lofty position, you've been involved with human nature in its base and lofty forms. The presumption of honesty of a witness you just use as an example, but it's not a platform from which you can begin to make a decision with regard to cross-examination, because it puts the cart before the horse, as is a presumption of dishonesty on the part of a witness. And what I say, therefore, is that this forum is in that regard no different to the previous fora where you have had judicial experience in trying questions of fact. There is no special magic about this forum that would lead a witness who's made errors to concede that they are errors, to make a witness who has made dishonest statements to suddenly become honest. There is no special magic in the witnesses here. They are human beings like all other witnesses. I am not going to go into the sharp differences between the evidence of Ms. Mentor and that of Mr. Gupta, or the evidence of Mr. Maseko and that of Mr. Gupta. But you have been exposed to the differences, and one knows that these witnesses have been on television, as I am now, in the public forum, giving interviews to the media afterwards, espousing their cause and their call that they are witnesses to what might be described as state capture. I ask again rhetorically, why on earth would you expect such witnesses to suddenly recant in the calm, professional, quiet, non-accusatory consultation with the evidence leaders and come clean, as opposed to be facing the direct, effective cross-examination with an element of surprise that will demonstrate to you their reaction? Why choose the different option? And if it is a question, and it's only a more minor point that you make, of course, of convenience, cost, and length of time, you must weigh that convenience, cost, saving cost, and length of time versus that which you deprive yourself of by in effect, blunting the power of cross-examination in the manner that I've described.
Oh, thank you.
Much of what we've just debated is covered, so I'll move.
Skip. Yeah,
yes,
that's fine.
But if I could resume, just to find my space, at paragraph 23, we submit that the Commission should be alive to the fact that in the fullness of time, recommendation...
I'm sorry again, Mr. Helens, I forgot to put one question to you, and you may or may not wish to be brief on it, but let me put it. In the ordinary course, a commission such as this one entails that there will be a team of investigators who would have interviewed witnesses long before those witnesses came to give evidence here. And in the course of that investigation, after obtaining a statement from one witness, they would need to go and see what the persons implicated in that statement have to say about this. Otherwise, their investigation might not give them a true picture. Doesn't that entail or mean that the nature of the function of the Commission has inherent in it a situation that the version of all parties might be known before there's a hearing? Leave out how it happened in this case, but generally.
Well, that would be a function of how the Commission chooses to set its investigators to their work. We would submit that if the investigators follow up on the evidence of Mr. Gupta with regard to Mr. Maseko, for example, and come across evidence either against Mr. Gupta's version or in support of Mr. Gupta's version, and in substantial or significant clash or watering down of Mr. Maseko's evidence, for example, then that can be dealt with after Mr. Maseko has been given evidence, taking both examples. I cross-examine Mr. Maseko and I say X was not the position on date Y, and that's the platform for all of your evidence. The evidence leaders lead him or other witnesses before the Commission that says X was precisely a fact on date Y, I would have stuck my neck out in cross-examination, or Mr. Gupta's neck out, and we would have been caught in a lie or an inaccuracy. The other example, I confront Mr. Maseko, X was not a fact on date Y, and that's the basis for all of your evidence. He crumbles and he says, yes, that's correct, but, and he gives some explanation. The evidence leaders can lead evidence or put to Mr. Maseko after cross-examination. We followed that up, and X, in fact, was not a fact on date Y. Why would it be necessary to expose Mr. Maseko to the entire version at all? The investigation could be done without exposing Mr. Maseko to that version.
Well, you see, if the investigators were to have interviewed a particular witness and who implicates other people, and they never went to those people to check what their version is, and then that witness and his or her version were brought up and he or she has to give evidence here, which takes 2 or 3 days or whatever. If later on you then come, or somebody comes with their client's version that is put to the witness, then it turns out that actually had they, that is the investigators, taken the trouble to interview those other people, they would have realized that this witness should not be called. But now they would have wasted everybody's time because they didn't check his or her evidence against other people.
No, that would not be the right conclusion for anyone involved in the Commission to reach, because on the example we have, and I'm not now making it Mr. Maseko or Ms. Mentor, this is this notional witness.
Yeah.
They come here and they give unreliable evidence, and by definition, unreliable evidence on your thesis implicating somebody wrongly, the position would not be that that witness should not have been called. The position would be that that witness should have been called only to be exposed as a witness wrongly implicating a person in order to aid you in your pursuit of the truth, to see not only whether there is so-called state capture, but whether persons are actually wrongly coming forward to propose a thesis and support a thesis of state capture when none exists. So, forgive my use of your judicial armchair, but when you lean back and say, that notional witness Smith, who came and told me this implicating story of Mr. Ajay Gupta in relation to topic X, which suggested state capture, it was all a fabrication. What does that lead you to conclude? A, I can't rely on the evidence of Mr. Smith? Yes, of course. B, and it will be the focus of cross-examination if it's allowed in the cases that I'm dealing with. B, if it's a fabrication, why was there a fabrication? Why did ostensibly proper evidence be led to me, leading me to a conclusion just on the face of it in favor of state capture, only for it to be shown not that it should not have been led, but that it is so untrue that there must be a motive behind the giving of such false evidence? That evidence of Mr. Smith must have been given to give you the other side of the picture that might exist.
Thank you. We have covered that part. The part that you still have to go through is, we should need about how much time?
Pardon?
The part that you must still deal with,
yes.
How much time would you still need for it?
I'll try to do it in 20 minutes.
Oh, okay. No, that's
20,
fine.
25 minutes?
No, that's fine. I think maybe we should take the short adjournment now.
As a court, please.
And then we'll resume at 11:30. We adjourn.
ask for your direction.
Yes.
We had previously indicated to you that we would introduce a witness from Treasury today. Mm-hmm. He is here, and he's unlikely to testify today, given the trend of argument.
Yes.
May we ask you to excuse him?
Yes.
Hopefully until tomorrow?
Yes.
And if we are able to accommodate his evidence tomorrow, then we would do so.
My understanding was that tomorrow was vacant, and because of that, certain other arrangements were made.
Yes, I understand.
So there might be difficulty with tomorrow.
We will then explore other options with him and convey them to your registrar.
Yes. That was my understanding as of, I think, yesterday. Yes. Either yesterday or the day before yesterday. Yes. But then we could have him as soon as possible next week.
Yes.
I don't know what his and everyone's availability is on Monday or Tuesday. You don't know whether he could make Monday or Tuesday?
I have not explored that option with him.
Yes. Maybe I should continue with Mr. Helens, and when Mr. Helens finishes, then we can deal with that.
Yes.
Yes.
Thank you,
if that would be fine.
Thank you.
Okay, thank you. Mr. Helens, I'll tell you what I'm really interested in that we haven't dealt with. Is the fact that your client, Mr. Ajay Gupta, I can't remember now whether also Mr. Rajesh Gupta adopts the same stance, namely that they are not prepared to come back to South Africa. They are, I think, in Dubai, and they are not prepared to come to South Africa. Is my understanding of the affidavit correct?
Yes, Mr. Chair. I was going to complete that last part of my address, quote something to you that's not in my head, and deal directly with that.
Okay, that's fine. Just do that. Yeah, do that.
I was at paragraph 23, 24 of my heads, and let me round off by saying that our submission is that by the end of the Commission's work, the Commission needs to be entirely satisfied that the evidence and information upon which it has reached its findings and conclusions is reliable and tested. No other approach surely could be adopted. Now, the quotation that I'd like to give you, and I'll show the book and everything for the actual reference to the evidence leaders, but I quote from Dr. J.P. Pretorius' book on cross-examination in South African law. It's not very long, and it's the latter part that is very important. But under the heading cross-examination in a commission, the learned author states the following: cross-examination by the commissioner may create the wrong impression. It is therefore recommended that the commission should appoint its own legal counsel to cross-examine on behalf of the commission. The purpose of cross-examination and chief examination differ to such an extent that both functions cannot be carried out by one person. As far as is practical and possible, there is thus a case to be made for witnesses to be represented, so that the Commission's legal counsel confine himself to the cross-examination of witnesses, I add, to the leading of witnesses. Then there's a reference in the footnote to the author Middleton, who says, it is, however, awkward to lead a witness sympathetically And we've seen that, and there's nothing wrong with that so far. And then all of a sudden, in brackets, by stealth as it were, to change your attitude to that of the hostile cross-examiner. Very often a relationship of trust is needed between counsel for the Commission and the community in order for witnesses to come forward. Legal representation for all interested parties is desirable so that, in quotes, biased cross-examination can take place. And there lies the rub, really. It's page 107, and my learned friend will have the reference.
Can I ask that you make available a copy of the relevant pages?
Yes.
So I'm not taking down the quotation.
Yes, we will. Then the next part of my heads I won't deal with at all. Yeah. The Commission to determine its own procedure. It's straightforward legal submissions. In a nutshell, you have to produce a fair and reasonable hearing in accordance with the principles of natural justice, but it is a discretion, objectively determinable should you, which you won't do, outside of a fair and reasonable procedure, but nevertheless of your own determination within those broad parameters. The issue that you raise with me.
Let me complete the issue that I'm raising.
Yes.
Firstly, I wanted you to confirm that my understanding of their affidavits, of the position of what they say in the affidavit is correct, namely that they are not willing or prepared to come back to South Africa. And I think they say, as I understand the affidavits, because the Hawks and the police, I think they say, are incompetent.
Reckless incompetence and a national embarrassment are their submissions.
So they, as I understood the affidavits, they didn't seem to go one step further and say they are incompetent and therefore what, unless I missed something. But I assume that it's in connection with, maybe it's in connection with your clients fearing that maybe the Hawks or the police could arrest them, I don't know, and do what.
Yes.
Is my understanding of what they say correct? And
yes.
You want to?
Let me explain the position that I'm instructed to put before you. Their attitude is, and I'll give their attitude and then I'll give their reasons.
Yeah.
Their attitude is that they will not come to South Africa to appear in this forum at this place in South Africa at all.
Yes.
Their attitude, however, is that they will appear in person before the Commission at another place, which can be agreed upon with the Commission, live in person before you, with the evidence leaders to cross-examine them, and they undertake to give evidence there at that place. Alternatively, by such video link as you deem appropriate, with them being not here and the Commission being here, and whatever scenario is adopted would include, obviously, let us assume that the proceedings take place with you present and the evidence leaders present at another place outside of South Africa. The tender is that those proceedings would be broadcast back to this venue or wherever you so chose, so that everyone who would see this Commission's operation as they do at this moment would see the Commission operating in respect of the Gupta's evidence and cross-examination. So it's at another place to be agreed upon, or together with video link back to this venue, if you so choose, or of them being in another place via video link, or such combination of those things, but I think I've expressed all of the combinations as might be acceptable. That's their undertaking. The reasons are twofold. Firstly, it's going to be argued to you that they are fugitives from justice. And I have, in a supplementary heads of argument, put forward that we have the following in regard to the Guptas. One, that there's a warrant out for their arrest, or a warrant out for the arrest of Mr. Ajay Gupta, but no one has seen the warrant.
Maybe before you deal with the contention that they are fugitives from justice, if you could just tell me what their reasons are for not wanting to come.
First of all, they have no clarity as to whether or not they are fugitives from justice. But secondly, and their main thrust, you've summarized it in brief, let me put it in full, it's in the papers.
Yes.
There are 3 examples given to you in these papers with judgments of 2 judges of the High Court in Bloemfontein and 1 judgment from a magistrate in Bloemfontein. Let me summarize them extremely briefly. With much fanfare in February, various people were arrested, including one of the Gupta nephews, Mr. Varun Gupta, and various persons who worked for various of the companies that operated in South Africa that were called, let's call them Gupta companies, and serious allegations of fraud and corruption were made against them. Flowing from, or as part and parcel of those criminal prosecutions, 2 separate ex parte applications were brought by the National Prosecuting Authority's Asset Forfeiture Unit, one in terms of Chapter 6 of the Prevention of Organised Crime Act, and one in terms of Chapter 5. Now, Chapter 6 is a procedure where you get a preservation order preserving goods and assets and monies pending the outcome of a civil forfeiture application in which the proceeds of crime are sought to be declared forfeit to the state. Chapter 5 is what's called a restraint order, where the assets of an accused person or a person to be accused are placed under restraint in the hands of a curator who holds them as a curator bonis pending the outcome of a criminal trial, in which criminal trial a prima facie case has to be made out that there is reasonable cause to believe that there might be a confiscation order. A confiscation order is something that is made if you are shown to have benefited from a crime. In order to show that you've benefited from a crime, you have to show that there might be a conviction. So in the Chapter 5, the High Court was asked on the papers before them, in the ex parte papers brought before them, the High Court was asked to decide, might there be a conviction? In the preservation application, the question was, need these assets be preserved because might there be a civil forfeiture order? On both scores, once the ex parte orders were heard on an anticipated return day, the High Court discharged those orders, finding that the test by the state, by the Asset Forfeiture Unit, by the National Prosecuting Authority, had been failed in dismally. As we point out in the quoted extracts from the judgment, both learned judges showed that the National Prosecuting Authority's Asset Forfeiture Unit did not understand banking, they did not understand the flow of money, and the accusations made to the various individuals and companies were wholly unjustified on their own case. Now, the attitude of the Guptas, and for example, with Mr. Varun Gupta, and I'm not going to be more lengthy than the point needs, but I'll make the point as concisely as possible. Mr. Varun Gupta was a director of a company, and he wanted permission for his bail conditions to be changed so he could travel overseas. And he said, look, I never played any executive role in this company, Oak Bay Investments Pty Limited. So insofar as you ascribe any wrongdoing to the company, I was a non-executive director. I simply never did anything. The state, in opposing his application to travel, trumped that argument with a card which doesn't exist in a pack of cards, and that is, but you were the chief executive officer of Oak Bay Resources Limited, an entirely different company where there was no connection between the two at all, certainly from the board of directors. They showed themselves incapable in exercising their prosecutorial discretion, their functions to oppose bail, not to oppose bail, to even see the difference between two entirely different legal entities. Mr. Commissioner, the papers in the bail application and in the Chapter 5 and Chapter 6 applications were so abysmal, were so lacking in foundation, that my clients take the attitude that they are facing the hawks who are incompetent in their investigating powers, as demonstrated in those two cases and the judgments, and a national prosecuting authority that wielded its power with reckless incompetence, charging people who should never have been charged and having their case exposed in these asset forfeiture applications as being wholly unfounded. Their attitude, I'm instructed to inform you, is they will not expose themselves to the attentions of the hawks who wield such unbridled power, and the NPA who wield such power when they do so with such reckless incompetence. So they will not come to expose themselves to bodies that behave in that manner. Now, the full detail of how poorly those cases are made out, pleaded, those non-existent cases are pleaded, is in the body of the papers before the court and the judgments that we've placed before you. So they take the stand that they won't come and expose themselves to such authorities. On the question of fugitive from justice...
Before you go there, I would have thought that if your opponent is incompetent, you would know that if they try and do anything to you with an independent judiciary that found in their favor in those matters, that you have nothing to fear, because in no time the independent judiciary will come to your rescue.
Well, except that the company Oak Bay and Era Haven and West Dawn and Mr. Varun Gupta and other persons remain accused persons subject to the arrest by such incompetent people who haven't worked out their case. So much so that recently, as a few weeks ago, the state asked for a further postponement, and now under Section 342A of the Criminal Procedure Act are on time limits to produce a case or not produce a case by the end of November, failing which the matter will be struck from the roll on the 4th of December. Now, before you, Mr. Commissioner, say, well, that's my point, Mr. Helens, the judicial system has operated in their favor all along. The answer to that is no, because before you can vindicate yourself before judicial officers, you do get subject to all of these awesome powers of the police and of the NPA before you get to the other end. And in the light of that reckless incompetence, they decline to be put through that mill.
Well, I assume that really what they are saying is we fear that we will be arrested by the hawks.
Incompetent police at the instance of incompetent prosecutors.
So what they are fearing is being arrested. Now, if you get arrested, isn't the position that you have a remedy if there are no grounds for you to be arrested? If you are arrested and detained, you can approach the courts on an urgent basis, and if there are no grounds for you to be arrested, there is no reasonable grounds serving as a basis for the arrest and the detention, any judge in this country will grant you a remedy.
Well,
and that remedy can be granted on an urgent basis, and we all know that urgent basis can mean within 24 hours, within 48 hours, within a few days, you can be out if you are arrested or detained. Now, if you have an incompetent hawks, as your client says, I'm not saying it, if you have incompetent police, incompetent NPA, doesn't logic say, then you have very good prospects that they will mess up. And if they will mess up, then you'll get an order from a judge within hours. So you won't stay a long time in prison.
No, it's not as simple as that at all.
but that ought to be like that in terms of logic.
No.
You are arrested by an incompetent police. They don't know what they are doing. They've messed up. You should not be arrested. You go to a judge. You show that these people don't know what they are doing. They have no grounds to arrest me. There are no reasonable grounds. Protect me. Get me released. The judge will give that order.
No, you don't get the docket until the crime is completely investigated. In the case pending in Bloemfontein, in order to try to get bail conditions adjusted, we try to get access to the docket to show that there's no case, and we were refused access to the docket. What happens is, and if you look at the judgments, it's not only a recklessness, there's a lack of integrity in the application of the mind of the National Prosecuting Authority and the Hawks, because no one could have reached the conclusion that those people should be charged on the basis of what was certainly in the asset forfeiture application. But in the docket, in the crime scenario, you can't challenge the decision to arrest and the decision to prosecute until you can have insight into the docket to show that there's no content in the docket, and that you only get when the investigation is complete. These people, by way of example, were arrested in February, and they are postponed to the 4th of December. That's a year later. And we know that in the background, the case must be that which is in the asset forfeiture applications, because there's only one National Prosecuting Authority. But in the context of the criminal trial, we don't have the docket in order to show that.
Thank you. And then another related question is this. If they seek to give evidence via a video link, that would mean that they are effectively outside the jurisdiction of the Commission, and the regulations, I think, and the Act, for example, make provision for certain things, such as I have the power to order a witness, I think, to answer certain questions that the witness might not have wanted to answer. They may be summoned and so on. So if they are giving evidence by way of video link, if I order them to answer certain questions, what can I do if they say we refuse?
Well, your coercive powers for someone within the jurisdiction would be absent. But it would bode very badly for them in terms of the subject matter of your terms of reference if, and I presume it would be on a matter of crucial importance or substantial importance or even of importance to your determination of the truth, if they decline to answer a particular question, the complete inference would be that their declining to answer that question means they can't answer the question in a way which was anything else but incriminating on a topic under the terms of reference. So you would be aided in your pursuit of the truth by the inference that you draw that they won't answer questions on crucial issues, and that inference would be drawn against them.
But why should I expose the Commission to that situation where it can be told, do whatever you like, I'm not answering that question?
Well, imagine the witness in the country. You might exercise such powers of compulsion or if you go so far as contempt of the Commission and an arrest, but you would still be not getting an answer, and the same conclusion would be drawn.
But the risk or the knowledge that the Commission can do something if a witness refuses to give evidence, that is a witness who is before the Commission here physically, that knowledge may serve as a deterrence to the witness to just refuse without any reason. But a witness who is thousands of kilometers away is not deterred by anything other than what you have just said, which also applies to the witness who is physically present, is not deterred by anything other than that from saying, you can do whatever you like, I'm not answering that question.
Mr. Commissioner, to be frank, there's merit in the point you make, I say with deepest respect. But what you have to do is weigh the loss of the evidence of Mr. Ajay Gupta, whom I represent, and his exposure to the cross-examination which he tenders, or by the evidence leaders or whomsoever, and the speculative possibility that that situation may arise. So what you have to do is this: justice incarnate, pursuer of the truth. There is a disadvantage to taking this evidence outside of my powers, as you've described, within the country. But if I proceed without that evidence, which is tendered, and full cross-examination is tendered, and I merely think that something like I've just suggested might happen, I don't know that it will happen, and I will be making a finding, a recommendation, and all based on findings of fact, having deprived myself of, let us face it, the very objects of this inquiry. I mean, this inquiry for the most part focuses, I beg your pardon, on Mr. Ajay Gupta and maybe the other two brothers to some extent. I must say there seems to be an easy confusion between the Gupta brothers, Ajay Gupta. I assure you there are three people there. So that is a weighing up mechanism that you must make. So when one day we're here and we stand in awe of your finding, and you make finding A, B, C, and D, if you are bereft of their evidence and their cross-examined evidence, then will you have the confidence to say, my finding is the best finding that I could have made? So I acknowledge the one defect, but I say the overriding consideration for justice, as you must do it, is to favor their request.
Let us assume that for whatever reasons, I refuse to grant them leave to cross-examine. It may well be that even in that situation, such evidence as the Commission's legal team already has in terms of his version, and such evidence as he may be prepared to give, even though there might be no cross-examination, may well need to be put to witnesses. In other words, it may well be the mere fact that, for example, leave to cross-examine is refused might not necessarily mean that whatever his version may be that may be placed before the Commission's legal team should not be put to witnesses so that the witnesses are tested against it. Obviously, it might not be, maybe I shouldn't say obviously, because I'm not in a court of law. It may well be that you would say it won't be the same as if you had been granted leave to cross-examine those witnesses. But it might not mean that their version, in so much as it is known, should be disregarded. What do you say about that?
That's a second-class citizen to good evidence. And how you would get past the quote from Middleton, which I don't say is the be-all and end-all, but it resonates with wisdom, that an evidence leader such as Mr. Maleka, for example, whose name I have got correct now, would lead a witness such as Mr. Maseko, and then turn on him and say, but fact X on date Y didn't happen, Mr. Maseko would be startled. How do you achieve that effective cross-examination, and unless it is done by someone such as counsel briefed by the Guptas? But let me add that going forward, therefore, on another topic, and we know there are many tranches of investigation, the Commission would write to us, notice in terms of 3.3, we're raising with you this issue about Transnet or Estina, which we know very well. Then the Guptas would say, well, we know what the ruling is. We give our evidence. It's dealt with by commissioners that have no deep understanding of our version. We put down a version, but they haven't met us. There's no instinct to cross-examine. You should remember, the statements that we've put are as full as we could make them for the purpose of what was required to show the difference. But when you have consulted with a witness, as the evidence leaders have consulted, say, with Ms. Mentor or with Mr. Maseko, you know much more about the background. You have a feel for the matter, so that when you cross-examine and challenge, you do so from the depth of consultation, appreciating the picture as given to you by your client, and cross-examining on much more than just the words on paper. So the function of testing the evidence would not be well served, even by hard-working, honest evidence leaders. And so what would a person such as Mr. Ajay Gupta do? He would say, well, I've already been told I can't cross-examine. I must put my version on paper as best I can. Some person who hasn't met me and doesn't understand the full picture will take the words on paper and work with them and try to achieve a demonstration of the truth before the commissioner. Why participate in such a failing or second-rate approach to evidence?
But what he would have been told, he would have to be told, Mr. Helens, is you are responsible for the decision to take yourself out of the jurisdiction of the commission. You are responsible for the situation where the commission's legal team can't interview you. Actually, if you had come back to South Africa, you may well have been granted leave to cross-examine, and you would have been able, one, to put before the commission as much as you could and challenge as much as you could to clear your name, if one wants to put it like that, and to assist the commission to find the truth. But you decided to take yourself out of the jurisdiction of the commission.
Yeah. Well, ultimately, the decision is yours, but that decision encompasses, I, the pursuer of truth, must decide whether to deprive myself of a very useful fountain of information, which information can be tested, albeit subject to the limping basis, if I could call it, that you have described. If you do so, I would submit, you would never have the confidence that you'd really got to the truth.
Just lastly, before you say whatever you might have on the issue of fugitive from justice, is it your submission that your clients have a lawful reason not to come back to South Africa? And if so, what are the grounds for saying they have a lawful reason?
They have, I'm instructed to put before you, that they have a reasonable apprehension that the South African police, in the form of the Hawks, with their powers of arrest and investigation, coupled with the National Prosecuting Authority's power to decide to arrest, has been demonstrably recklessly wielded against their companies and against individuals that represented the companies, and they have no confidence that the same would not happen to them. That is their justification.
Thank you.
Then I have filed, very briefly with your leave, supplementary written submissions, which I won't go through, but I'd ask you to address yourself to. Just on the question of fugitive from justice, it's in paragraph 10 of my supplementary heads. First of all, 10.1, it's a point I've already made. He shows the correspondence with the South African police where they don't give any clarity as to whether there's a warrant or not. Clearly, he didn't flee the country knowing of a warrant. This has come up lately. The Commission argues that one or more of the Guptas are fugitives from justice. Well, we don't know what that means, whether it's one or more, and if so, which one. The press say that the police say there's a warrant for Mr. Gupta, but there's nothing before you to say that there actually is a warrant for Mr. Gupta. So this whole question of whether there is a warrant is completely up in the air. In particular, my learned friend's submission that there's a warrant for one or more. Oh, I don't know what that means. So we say there's nothing before you to say that there is a warrant. And we say that his attitude is the one that I've expressed with his experience in the Estina prosecution.
Yes. If he or they are fugitives from justice, it may well be that that disqualifies them from participating in these proceedings. It may well be that it doesn't necessarily disqualify them from participating in these proceedings, but nevertheless, it is an important factor that I must take into account in the exercise of my discretion whether to grant them leave or not.
I'll make 2 points in that regard, if I may. We raise in our heads the same case as my learned friends raised, Polanski, who was a fugitive. The court and a commission is a wider body than a court, looked at all of the factors, one way or the other, of which the fact that he was a fugitive from the Californian jurisdiction was a factor. So it is a factor you must take into account. And it decided in his favor. Then there's the New Zealand or the Australian tax authority case, which went the other way. We've also given you recent authority, South African authority, within the context of high court proceedings, where evidence by video link is very much an acceptable way in justifiable circumstances, where a court can take evidence from overseas if it's justified because of we live in a global village now. So the fact that it's, and this is not quite answering your point, but the fact that it's a video link, etc., it makes the evidence no less real, no less cross-examinable. So it's absolutely as good as being here. It's one limping nature is your compulsion under the Act. So you have that factor, and you have the, if you like, the theoretical or the in-principle fact that you may find that he's a fugitive from justice. I must say there's no clarity on that issue here. Those are two factors that you will weigh. They are entitled to weigh. It's not irregular for you to weigh them from an administrative point of view. You can name them as factors, but you must look at the balance. And that is, you'll get the evidence, it'll be cross-examined, it will emerge whether they refuse to answer questions or not, and all the benefit that flow from that. And a commission, if the courts will allow video conference facilities, restricted or constricted as they are in their procedure, with a discretion to allow it, then on the wider beam of the powers of a commission, you should be more favorably inclined.
Thank you. I'm sure you have had a look at the decision referred to by the Commission's legal team, the decision of the Constitutional Court in Hansman.
Yes.
Where, as I understand it, once the court came to the conclusion that the applicant there was a fugitive from justice, it decided that it would not entertain the application as I understand it.
The difference there, if I might, Mr. Chair,
yes.
The difference there is that Hansman, within the legal system, was approaching the Constitutional Court for leave to appeal, both trying to use the legal system to enforce his rights and both denying the legal system its right to have imprisoned him and he had absconded. That is a very different position from this position.
How so?
You are enjoined to make an inquiry into the topics covered by the terms of reference. An important source of information that would be useful to your decision making is the evidence of the Guptas. They are not trying to conduct the inquiry or run a process. Their evidence is something that you would naturally come across in the many phases of the progress of this commission, and where you ask them if they want to participate and give evidence and or cross-examine, they make a tender to participate with a qualification. And it's not the same as seeking to demand from a court participation in a process as opposed to being a ready source of information for the Commission's functioning.
Well, but what remains is that such participation as they tender is one that is in their terms. They say, we will participate, but on our terms. We will be outside of this country, and you either come to us as a commission, or we go to whatever venue you like, but outside South Africa, or through a video link. So they want participation to be on their terms.
Well, it could be phrased like that, and that might be a pejorative way, but given the reasons that they have given, they nevertheless tender participation. And if the pursuit of truth is to be aided by their participation, albeit on the terms that they have suggested, it remains a value judgment whether you wish to conduct an inquiry unaided by their evidence or aided by their evidence, even with some rebellion in your judicial soul as to whether you should accommodate such a request. It's a balancing act, and it's one that you have to achieve.
Yeah. No, thank you very much, Mr. Helens. If I were to grant them leave, the next question would be the duration, because I think I've indicated that I do intend putting some time limits on cross-examination. As I see it, I probably would initially say to you or any counsel, I think I'll give you, for argument's sake, an hour, you know. Obviously, I wouldn't be rigid about that. So, but I would, if you are going to be too long-winded, that might count against me giving you more. But if I can see that the hour comes to an end, you still have quite something to ask the witness, and you really have been asking relevant, pertinent questions, you know, I'm more inclined to give you a little more, you know. So in other words, I could initially put a certain time frame, and then see how things go, and then towards the end maybe give you more, and so on. In the end, I have said before that this process will be a fair process. But a fair process doesn't necessarily mean that everyone gets what they want. It's going to be a fair process in the sense that, as far as possible, the rights of all people will be looked at, they'll be considered against other people's rights, against the public interest, against taxpayers' money that is used for the commission. So, but I would try to be as fair as possible, but there would be times when I'm sure I make certain decisions and somebody thinks I'm unfair, but I'll simply be doing the best I can. And one of the things I don't want is I don't want commission's proceedings to drag on for too long. So I have to balance that, however, against other considerations to make sure that I strike a fair balance, as fair a balance as possible between not wanting the proceedings to drag on for too long and not wanting to be unfair to other role players. So I'm not sure whether you have anything to say in terms of time frames. Of course, the time frames can only be in relation to a particular witness.
Yes.
In regard to another witness, you might need less time than in regard to another.
Let me say, on a note that you're not asking me about, as a cross-examiner, I'm very to the point, so I'm unfazed by such a restriction.
Okay.
In principle, though, the sense of, say, what Mr. Maseko said versus what the cross-examination might be, I can readily see that the cross-examination of Mr. Maseko might be substantially shorter than the cross-examination of Ms. Mentor.
Yes,
and just to, not to delve into the facts of that case, there will be many scenarios where there'll be more or less time.
Yes.
If the cross-examiner knows that an indication of 1 hour is the ballpark, the cross-examiner should and will, I would, keep myself to that hour as far as possible, and to the extent that you run over, it will be palpable from what's happening as to why it's justifiable. So I would I would not kick against such an approach at all.
Yes. Okay. Thank you very much.
Thank you, sir.
Thank you, Mr. Helens. Is it Mr. Yupe who is next? Or who is next? Mr. Jupe. Yes. Or the issue of the witness. Okay. All right. Part of the reason why Mr. Yube allowed the debate/discussion between myself and Mr. Helens to be as exhaustive as I think it was to give everybody who is still going to come up and argue the benefits of what's going on in my mind, but also of hearing arguments advanced by Mr. Helens on certain issues, so that to the extent that same issues arise, if a particular counsel is happy with the argument put forward by Mr. Helens, all they might say is on the following points, A, B, C, D. I associate myself with what Mr. Helens has argued and have nothing to add on those points, or I only have a limited input to make, and you make that, so that we don't effectively repeat the same thing. Obviously, if you have different arguments, that I would understand.
Yes, Mr. Chairman, I've dealt, I believe, in sufficient particularity with all the aspects, more specifically with the rules of natural justice, and insofar as they overlap with the argument and the responses advanced by Mr. Helens, I obviously align myself with that, and I'm not going to repeat it.
Yes.
Perhaps I should only address the different issue. Mr. Chairman, you know what is my instructions with regard both to Mr. Ajay Gupta and Mr. Rajesh Gupta on the meeting of the 23rd of October 2015, and what the versions are with reference to their affidavits.
Yes.
I also represent Mr. Duduzane Zuma.
Yes.
Now, I've dealt on page 26, paragraph 5, with the issue that he stands on a somewhat different footing.
Yes.
We have explained that in terms of the the proclamation dated 20 March 2018, no answer given by any witness in these proceedings will be admissible against him in any subsequent criminal proceedings. But there is no exoneration, and to the extent that he is required to make an election under legal duress, which he is currently faced with, either to give an undertaking to you, Mr. Chairman, that he is prepared to come and give evidence before this commission, and currently facing criminal charges forming the same subject matter. As you know, it is set out in paragraph 6 that when he arrived back in South Africa to face a culpable homicide on the 12th of July this year, he was arrested on the 9th of July with regard to the exact same subject matter, which is the subject of the evidence of Mr. Jonas, which would have occurred apparently during that meeting on that specific afternoon. Now, as set out in paragraph 7, page 27 of my heads, at the time of his arrest, he was entitled to be informed, number one, whether there was a warrant for his arrest, and number two, what is the affidavit, a copy of the affidavit in support of that warrant to arrest him for these specific charges. The submission is, and with reference to your earlier questions to Mr. Helens, but if somebody gets arrested unlawfully, maliciously prosecuted, he can simply sue the state for damages. But
well, he can approach a court and get an order that he be released
on bail.
Well.
And then he has to go through a prosecution and face that prosecution to show eventually he was maliciously prosecuted, only on a theoretical basis. But to put it in the correct context, Mr. Commissioner, with respect, it shouldn't happen like that. Because the point of departure is we either live in a constitutional state or we don't. Nobody should be subjected to an unlawful arrest and an unlawful malicious prosecution. Is there no basis for it? For instance, if I may just put this arrest in context, because we were given information as to how that this arrest came about on this specific charge. Now, we know now from Mr. Jonas that he claims that at the meeting on the 23rd of October 2015, a certain topic was discussed. He kept quiet about that topic that apparently was discussed between the people who he claims to be there. Up until the 16th of March 2016, when in a media statement by the ANC, it was stated the following, and one has to look at the words he used. He says members of the Gupta family made him an offer. Now there, in that statement, he implicated more than one person. Subsequently there too, on the 11th of August 2016, before the public protector, he gave evidence under oath. And when one reads that you will find in Exhibit A, page 27, when one reads that, he came there before the public protector, for instance, and he says, look, I don't know who I really met because that person didn't introduce himself to me. He may be the one or the other. And then by way of a leading question, it was put to him, but it must be Mr. Ajay Gupta. Then, subsequently thereto, in an affidavit on 16 February 2017, he makes, I'm just giving the short abbreviation just to explain the unfair process. He says, well, the person I met was Mr. Ajay Gupta. On the 8th of August 2018...
But what I'm keen to, in order to understand what you are telling me to hear is, what is the point you are making about this context?
The point is...
What's the argument that you are putting it forward as a foundation for?
The point is the following, Mr. Commissioner. From the evidence of Mr. Jonas, it appears that he hasn't laid a criminal complaint or a charge officially against anybody with the police. Yet, Mr. Duduzane Zuma gets arrested. On what evidence?
Yes.
It is unclear and plain. Nobody can get arrested if there's no official evidence under oath which implicates you in an offence.
Yeah, no, I understand what you're saying, but in the context of his application for leave to cross-examine, in circumstances where he says, I will not give evidence before the commission because of the pending charges, what's the relevance of that? What's the point you want to make about the fact that he was arrested in circumstances where Mr. Jonas, as you put it, says he didn't lay any charge?
Because he currently is facing a parallel criminal charge in the Specialized Commercial Crimes Court. He prefers, if he needs to make an election under legal duress, rather than not to give evidence before this commission and take his chances, and will deal with the matter in a criminal charge he's facing.
But I don't understand the stance that he takes of saying he won't give evidence here because he is facing a criminal charge in respect of the same allegation. Normally, a person would take that stance on the basis that they don't want to effectively incriminate themselves, they don't want to give their version first before the criminal proceedings are completed. But hasn't he given his version already in an affidavit?
Yes, he has.
So why does he not want to come and testify?
Well, my instructions are, Mr. Chairman, that he prefers not to give you an unconditional undertaking that he's prepared to give evidence before this commission at this stage, whilst he is facing criminal charges which he believes in circumstances where he could never have been arrested in the first place.
I mean, I just struggle to understand. If he had not given a version, maybe it might have been different. And obviously, the rules of the commission require that if you're implicated, you must give a version. He has given a version.
Yes.
We know it. If he has already implicated himself, he has, and it's an affidavit that's a public document. Yeah. Is that a lawful reason? As I said when we were meeting in chambers, in his affidavit, he hasn't said he would refuse to come and testify if he is called upon to do so. Maybe he simply said he does not undertake to give evidence. Maybe I must ask you the question, if you do have instructions, whether his position is that if I call upon him to give evidence in terms of the powers vested in me, whether his stance is that he will refuse.
At this stage, my instructions, Mr. Chairman, is that if he needs to make an election, he prefers not to give evidence. Okay. Maybe if he gets a subpoena by the commission, he may revisit his stance. But currently, yes, as we stand here,
yes,
and insofar as he may be under legal duress to make an election, that is his election. Okay. Because the reasons he advanced is that he's currently facing parallel criminal charges, and on his assessment of the events, it only shows the conclusion he reached that he was not given fair treatment under the Constitution like any other ordinary citizen, because if there's no criminal charge by the main witness, how can he ever be arrested for the allegations?
There are many people in the country, citizens and non-citizens, who get arrested, who get charged in circumstances where they should not have been arrested and they should not have been charged. And all of those people use subject themselves to the legal system and try and get protection by using the legal system. Now, he has told us his version, and all that would remain is that he may be asked to say, okay, help this commission to establish the truth. There are these allegations against you. You have denied them. The witnesses who make allegations against you have taken the stand. They have subjected themselves to cross-examination. Take the stand as well. Subject yourself to cross-examination like them. And he says, no, at least as of now, he's not undertaking to. And we don't know whether, if he was served with the requisite process, we don't know whether he would refuse or he would not, as you say. I'm just concerned whether in these circumstances he would have a lawful reason to refuse if he were to be summoned to appear before the commission. And of course, if he were to be advised that, for example, there is no lawful reason, he might well decide that if the commission asks him to come, he won't wait to be summoned. He will make himself available and say, I will come in and give evidence if the commission asks me to do so.
Well, as I say, Mr. Commissioner, my instructions as I stand here, he hasn't given leave to cross-examine yet.
Yes.
He explains to you why he is so disappointed in being treated in the way he was. Clearly, unfair treatment, unlawful arrest shouldn't be countenanced by anybody or any court, and it shouldn't happen in the first place. It's improper to say, well, it happens and then you have your remedies. We can't live in a state like that.
Well,
it should be done correctly in the first place.
Well, Mr. Yube, I'm sure you have represented many clients who have gone through that and they have found protection or at least justice. We as a country, we can't have a police force, police service that is perfect. No other country has such a police force that is perfect. There will be weaknesses. We have in our constitutional democracy checks and balances. If the police arrest you without good grounds, the courts are there to declare that that's unlawful, they must release you. Those are the checks and balances which every citizen makes use of. Why should there be some people who don't seem to want to let what happens to everybody happen to themselves as well, subject themselves to the same rules that everybody, rules of the country that everybody gets subjected to?
Well, probably, Mr. Commissioner, once the ruling is made and the invitation or the ruling is that he will be granted leave to cross-examine on the precondition that he must come and testify and he will get a subpoena. Once that the event occurred, I will get instructions and then come back to the leaders and your good self.
Yes, no, that's fine. Just one last question in regard to his stance. Do you not concede that leaving out the issue that he has disclosed his version, leaving that out for the time being, do you not concede that if this commission were to make a ruling to the effect that if an implicated person is facing criminal charges, he is entitled not to testify, even in this commission, even if called upon to do so by the commission. Do you not concede that that would mean that the life of this commission would be extended for a very long time? In his case, as I understand the position, his next appearance is early next year.
On the criminal charges, it is the 24th of January 2019.
Yes.
Which is a holding date, a provisional date.
Provisional date, so yes. Not even the trial.
Not even the trial.
So the trial could take quite some time, and apart from that, there could be other people who in due course come before this court and say, I'm an implicated person, but I'm facing a criminal trial, criminal charge, so I'm also refusing to testify now until my trial has been finalized. And another one comes and says that, so we'll go into 5 years and more. Is it a tenable position for this commission to uphold the position that despite the amended Regulation 8.2, an implicated person who is facing criminal charges is entitled not to be summoned to give evidence, or is entitled to refuse to give evidence?
Well, facing with the position I am now, there may be many eventualities. Depending on what happened, they may withdraw the charges because they say, or may come to the conclusion that he didn't take any part, number one. But number two, in my view, every witness who is facing criminal charges and is called upon to come and give evidence after being subpoenaed must either adhere to, and if he doesn't adhere to, he will have to advance reasons why he doesn't comply, or elect not to comply with the evidence, and deprive this commission of his version.
But you can see what the possible or even likely effect would be on extending the life of the commission if the ruling was to say any implicated person who is facing criminal charges is entitled to refuse to give evidence before the commission.
Well, one has to deal with that,
yes.
that reality or eventuality once you are faced with it.
Yes. Okay, and is your position on timeframes for cross-examination, if I grant it, the same as Mr. Helens?
Indeed, sir.
Okay, thank you very much. Thank you. Which counsel comes next?
Thank you, Mr. Chairman. On behalf of Ms. Kaunda's application.
Please just give me the spelling of your name. I'm sorry.
C-O-W-L-E-Y.
C?
C-O-W?
Yes.
L-E-Y.
Thank you.
Thank you, Mr. Chairman.
Well, in your case, Ms. Kaunda wants to come and give evidence, if I recall correctly.
No, Mr. Chairman.
Oh, she doesn't?
No.
Oh, why did I think she does want? I thought she does want to come and give evidence in terms of her evidence.
No. She takes the position and says, I made an election in terms of Rule 336, not to testify, not to call witnesses, but I want to cross-examine Ms. Mentor on a very, very narrow aspect. And why we submit okay, let me just get this clear. It's one thing to decide whether you want to undertake to give evidence. It may be another thing to take a position that says
even if the commission calls upon me to give evidence and I'm summoned, I will not comply. Do you know which of the two positions her stance is?
Insofar as the latter is concerned, that is within your prerogative, Mr. Chairman. You can decide to summon her, and then she has no choice but to appear, and she must comply, she must respond.
Then I understand.
Yes.
Then I understand. So it's not a situation where she is she doesn't want necessarily to give evidence. She might just be thinking after cross-examination there might be no need, or I might say after this cross-examination there is no way the commission could take the witness's version, and even if I don't give evidence.
With respect, Chairman, that's exactly our approach.
So it's not a question of any hostile attitude towards the commission.
Absolutely not. And my client definitely understands the position of her own position as well as that of the commission and where she fits into this.
Yes.
So the reason...
Okay. My inclination in regard to her is the following. One, I was thinking that, the point of difference between herself and Ms. Mentor is so narrow. I was wondering whether she feels really strongly that she wants to cross-examine, or whether, in the light of her version, the Commission's legal team can basically take care of putting questions to the witness, and bearing in mind certain things that were said by the witness. I think the witness said she's confident or sure that it was her who called her, but I think there was a question of not knowing the number that had been used and so on.
May I address you on that particular aspect? What we've been trying to ascertain from the legal team over the past few days after the evidence of Ms. Mentor was we want the telephone numbers which you refer to in the evidence in chief. We've managed to acquire one of those telephone numbers. We are in possession of Ms. Kaunda's cell phone records for October. If we have the telephone numbers, we can compare them with the cell phone records. That can be presented to the legal team, and they can then make an objective observation to see whether there had been any telephonic communication. We wanted to supplement Ms. Kaunda's application, but the fact that the numbers were not forthcoming, that prevented us from getting finality on the issue. So once we are there, then we can get to a point where maybe a concession is made, and that was our approach right from the onset.
Yes. No, that's fine. If that is the approach, maybe what we should do is allow you to try and see if you can find whatever information you are looking for. As I see it, it's quite possible that you might be quite comfortable, and the legal team of the commission also could be comfortable to say, look, we have got Ms. Kaunda's version, we've got this and that, we'll put to the witness. But if it is thought that that might be unfair to her, I would be inclined to grant leave to cross-examine. It's just that it's such a narrow issue. If one would like to do without having to have too many people coming in just to cross-examine on that. So I would be inclined to grant the leave. I would restrict cross-examination to a very short amount of time, saying that is a very narrow issue. But so I suggest that maybe what we should do is maybe leave this pending, let you continue to talking. Once and on any of the days arrangements can be made, where once you have reached agreement or whatever, you both let me know, yourself and the Commission's legal team. But that's my inclination in terms of misconduct.
Thank you, Mr. Chairman. We take the lead.
Thank you. Thank you. Who is the next? I would prefer Mr. Lebala's one to be the last one, because is it not a little different compared to the others? If I could deal with the others first. Yes, let me deal with the others, and Mr. Lebala could be. Oh, I'm sorry. Or am I changing the rules that we agreed upon in chambers? I said maybe after the counsel who would deal with the matters that required substantial debate are done, then I would let the legal team for the commission respond before I go to the other ones.
I've taken on the role of organizer here, and we had Mr. Lebela next, but what you wish should be done. So we'll take him last.
Well, Mr. Lebala's one definitely should be last, but it may well be that the other ones that are left might be more or less might not be difficult to handle. Maybe we should deal with those ones. Maybe we might be able to dispose of them in some way in the next 10 minutes or so, so that after lunch then we can just have full argument from the Commission's legal team.
Let me try and organize.
Because otherwise, Mr. Malega, I would interrupt you for the lunch break in 10 minutes' time.
Let me try and organize.
Yeah, okay, all right.
Chair, if I may assist.
Yes.
The remaining applications are of persons who undertake to testify.
Yes.
And we have made it quite clear in our submissions that we do not oppose those applications.
Yes.
So that we should hold them to their undertaking to testify after cross-examination.
Yeah.
In the event they do not live up to that undertaking, we would certainly approach you for a subpoena.
Yes.
Force that undertaking. So I don't think that there is a debate between us and the rest of the applications.
Yes, no, but what I was meaning is that might mean that before lunch I could dispose of those.
Yes.
Because if I say you must start, I will interrupt you at 1 anyway.
Yes.
So if I dispose of those, then counsel who are involved, if they don't wish to come back after lunch, then they are free. Then when we resume after lunch, then you take the stand.
Indeed.
Yeah, okay, thank you. Yes, I think counsel let me allow Mr. Helens to be the leader there.
Thank you, Chair.
Please just give me your surname again.
It's Siwela.
Siwela.
Yes.
Okay.
Yes, Chair.
Yes, you appear for Mnonopi and Mtolo.
That's correct. Chair.
Mr. Maleka has just said that all those who remain undertake to give evidence. I thought that was the position earlier, but I seem to have, I'm under the impression that I read something recently that might reflect a different position in regard to one or both of your clients.
That's correct, Chair.
Or is there a change?
There's certainly a change, Chair.
Oh, yeah, I thought I
with regards to both matters,
yes.
Parties.
Yeah.
And by seniority, I will start with the Major General Mnonopi's application.
Yeah.
And we state, Chair, that upon receipt of the notice.
Well, let's go straight to the issues that are really important.
Yes.
Is there any one of them who is not prepared to testify,
That's
even if called upon to do so?
not really, not only to testify, Chair, but also to cross-examine. So the instruction, my instruction is that I withdraw the entire application.
In regard to both of them?
In regard to both of them. The reason being, what transpired in the peripherals of this inquiry, if we proceed with these applications, it might severely prejudice the general. So therefore, I've been instructed.
Or both of them, or just the general?
Only the general. I'm still coming.
Is it a general? Is it, I understand these titles can be very different. It's Major, General, and General are different things.
Yes.
And brigadiers.
Let me be specific. Yeah. Thank you, Chair, for your guidance. Major General Mnonopi.
Yeah, that is lower than general, isn't it?
Yes.
Yeah. Even if it says major before general.
Yes, because we also have lieutenant general.
Yeah.
Yes.
Okay. So you say your instructions are to withdraw the applications of Mtolo and Mnonopi for leave to cross-examine?
No, not Mtolo. Only Major General Mnonopi.
Okay.
Yes.
Okay. All right. Thank you. I hope she appreciates that. That doesn't mean that she might not be called upon in any event to come and give evidence if I consider that she should be called upon in terms of the regulations. But I assume that she knows.
Yes.
Yeah.
And then...
okay, so that one is withdrawn. Then it's Mtolo.
Yes.
What is his position about giving evidence?
His position is that we have a special application, Chair, in that I don't know if Chair had a glimpse of our supplementary affidavit, and if so, I would humbly and respectfully refer Chair to paragraph 3 thereof, where he
well, even if you don't read, if you know what he says, you just tell me this is his position on giving evidence.
He just confirms under oath that he has in his possession and control recordings of the interview between himself and Ms. Mentor.
Yeah.
Yes. I've canvassed this with the legal team through...
well, my question is, what is his position on undertaking to give evidence?
He wants the Chair to make a ruling on the admissibility of this tape first, before the next step may be considered, whether we want to cross-examine.
But he has brought an application for leave to cross-examine. He places before me information. I must decide that application. Now he wants to say, please don't decide the application yet. First tell me whether this recording will be admissible. I mean, we here, the commission is investigating certain allegations, and he has certain things have been said about him. He knows whether they are true or not true. He has put up a version, and
yes, certainly.
I would have thought that if he has a recording, he would act on the basis of what he is advised by his legal advisors about whether that recording can help or not.
Certainly, that's why in this instance, we need your unquestionable guidance, Chair.
Well, I want to rule on the whole application.
Yes.
If you make your submissions on whether he can use that evidence of the recording, you can make those submissions, but I will rule on everything at the same time. I won't rule piecemeal.
Yes. Then if in that instance, Your Chair, we still stand and abide by our humble submission as clearly and explicitly set out on our supplementary affidavit. Yes.
Now, but then I don't have an answer about whether he undertakes to give evidence as of now. Eh?
That goes without saying.
He undertakes.
Yes, we undertake
to give evidence.
To adjust whatever when called upon by this honorable commission.
Okay, all right.
Yes.
Okay.
Yes.
If there is no problem with regard to that, I would be inclined to grant him leave. But I would suggest that if he has a recording of a certain conversation, it might be helpful if you might wish to consider whether it would not be helpful if you were to share that recording with the Commission's legal team, because it may well be that, for example, if that recording is shown to relate to the witness concerned, and if she says certain things there and there is no problem with the authenticity, it may well be that some of the things might be resolved. I'm not sure. So I'm just thinking if there is a recording, there may or may not be a chance of curtailing whatever cross-examination might end up happening.
Yes.
So I would suggest that you have further discussions with the Commission's legal team on the understanding that I would be inclined to grant you leave, and then what would remain is how much time I would give you to cross-examine. But it may be possible that further engagement with the Commission's legal team might curtail the length of the cross-examination.
Yeah, that's correct.
Yeah.
As I've pointed earlier, Chair, that I've already canvassed this with Mr. Mabunda.
Yeah.
He only stated that as long as we will comply with all the rules regarding the handing in, there is no problem.
Yeah, but what I'm saying is speak to the legal team that's in front of you. That's next to you, not in front of you. That's next to you.
Yes. Sure.
So talk to them, to counsel, and see what is possible and what's not possible. And in due course, a report back would be made to me in open commission, open court, and then we'll do the formalities when you are supposed to cross-examine in terms of the formalities. But that's my inclination. So, but see if that can be sorted out.
All right.
Okay.
Yeah, thanks, Chair.
All right.
That's my submission at this stage.
Thank you.
Thank you.
Okay. Is there another one before Mr. Libala? No. Oh, okay. Mr. Libala?
Esteemed Commissioner, we come on a different, complete point, and will edify it for the benefit of assisting our learned friends, the evidence leaders. Mr. Helens did not deal with a very important aspect that is borne by Rule 3.3, Rule 3.3.1, and Rule 3.3.2.
I'm sorry, Mr. Libala. How much time do you think you might need for this application, subject obviously to my questions? I did have a look at your client's application or document earlier, but I don't think that I saw. I think you said it's updated or it's supplemented, or is it still the very one that was filed?
It's the same, Chair. This one that you should look at now, it's signed. The difference is this.
Oh, the difference is that it is signed.
Yes.
Okay, all right. I did have a look at it some time back, but from the discussions we had when all counsel met me one of the days, there was the issue of whether your client at this stage is implicated.
Indeed.
And a lot would then depend on that.
Indeed.
You are here to argue that she is implicated, and if that proposition is accepted, then you would move an application for leave to cross-examine.
Indeed, Chair. And we contend that the answer is not in the tacit assumption of the interpretation of the rules by our learned friends, the evidence leaders. Rule 3.3, 3.3.1, and 3.3.3.2 talks about a person who may be implicated.
Yes, yes.
Ms. Brown is a very unique witness or participant.
No, I'm sorry. When I was asking how long you might be, I wanted to see whether to deal with this now or to deal with it after lunch before I can deal with here the legal commission's legal team's argument. How long do you think you might be?
Chair, 15 minutes, 10 minutes, subject to the questions that you propose.
I'll tell you what, I think let's adjourn for lunch. I'll then, during the lunch, just refresh my memory on that application. And then when we start at 2, we'll deal with your application, and hopefully we can finish it within 15 or so minutes, and then I'll hear Mr. Malega or whoever from the Commission's legal team will present argument on what Mr. Helens argued earlier this morning.
Thank you, Chair. Thank you.
Okay. Thank you. We'll then adjourn until 2 o'clock.
All right.